Lord, election to Ladakh Autonomous Hill Development Council, Leh, is held in October 2020 for 26 seats. And for Kargil, it is going to be held on 10th of September 23. So Ladakh election would be over. But I may, my lord, your lordships need not open, my lord. It is volume 10, document compilation volume, page 763.
Document compilation volume?
Volume 10, page 763. But I am reading 4 lines from Lok Sabha and 4 lines from Rajya Sabha, because something said on the floor of the house has its own sanctity. Therefore, my lord, I am reading it. Lord, your lordship says, my lord, page 763, my lord, volume 10. Because the Honorable Home Minister introduced the bill and it was debated. It was debated for both the days.
This is Lok Sabha, this one?
This is Lok Sabha, my lord. What I am reading at page 763 is Lok Sabha. All members participated in the debate and my lord, relevant is the last para. अध्यक्ष महोदय, मैं अनुच्छेद 370 की बात बाद में करूंगा. सबसे पहले मैं इस चर्चा में काफी सारे सदस्यों ने भाग लेते हुए कुछ चीजों के बारे में जानना चाहा है, कुछ मुद्दे भी उपस्थित किए हैं जिनका मैं सबसे पहले जवाब देना चाहूंगा. काफी सारे विपक्ष के सदस्यों ने कहा है, सम्मानीय सदस्यों ने कहा है कि यूटी क्या हमेशा के लिए है, यूटी क्यों बनाई गई है, यूटी कब तक रहेगी. सोएन ने भी कहा. मैं इस सदन के माध्यम से पूरे देश के सामने और विशेषकर घाटी और जम्मू, घाटी मीन्स मतलब वैली के लोगों के सामने स्पष्ट करना चाहता हूं कि जहां तक यूटी का सवाल है, परिस्थिति सामान्य होते ही उचित समय पर पूर्ण राज्य का दर्जा देने में इस सरकार को कोई आपत्ति नहीं है.
It's just read the last 3 words again. Is it say पूर्ण राज्य?
पूर्ण राज्य का दर्जा. आई जस्ट रीड. मैं इस सदन के माध्यम
फुल स्टेट
मैं इस सदन के माध्यम से पूरे देश के सामने और विशेषकर घाटी और जम्मू के लोगों के सामने स्पष्ट करना चाहता हूं कि जहां तक यूटी का सवाल है, परिस्थिति सामान्य होते ही उचित समय पर पूर्ण राज्य का दर्जा देने में इस सरकार को कोई आपत्ति नहीं है. मलोड 512 is Rajya Sabha, my lord. Here also, my lord, this question arose. Lord, somewhere 10th line from the top, my lord, it starts with कई माननीय सदस्यों. But I am on page 162. I'm sorry, page 512. Your lordship has one. My lord.
After that, after the English words, constitutional position.
No, उससे the same line. अगर सभापति महोदय की आज्ञा हो तो मैं पूरी कॉन्स्टिट्यूशनल पोजीशन सदन के सामने रखने को तैयार हूं. एक माननीय सदस्य ने पूछा कि कब तक यह यूटी रहेगा. मैं माननीय श्री सोएनसो और जिन अन्य माननीय सदस्यों ने यूटी के बनने पर आपत्ति दर्ज की है, मैं निश्चित रूप से उनको आश्वस्त करना चाहता हूं कि जैसे ही नॉर्मल परिस्थिति हो जाएगी, उचित समय आएगा, इसको फिर से स्टेट बनाने में हमें कोई एतराज नहीं. मैं आज इस सदन के माध्यम से जम्मू कश्मीर की जनता को भी कहना चाहता हूं कि जम्मू कश्मीर भारत का मुकुटमणि है और इसमें कोई मतभेद नहीं है. जब भी उचित समय आएगा, मगर आज जिस प्रकार के भाषण हो रहे थे, मुझे लगता है थोड़ा लंबा समय रहेगा, एटसेट्रा एटसेट्रा, क्योंकि इस भाषण इसके बाद घाटी में भी होने वाले हैं. दैट वाज माय लॉर्ड एन एप्रीहेंशन.
What's the date of this?
5th of August 2019. when reorganization bill was being considered. May I quickly, my lord, take your lordships through the judgments, my lord, on Article 3, 4. Whichever way, my lord, your lordships would like me to go. But I'll read, my lord, only cite few judgments on
All right, let's.
reorganization and 356.
All right, where are they, Solicitor?
My lord, 162. My lord, your lordships have
Which
read
compilation?
my written submission, volume 3, combined written submission. My lords have seen Article 3 and Article 4. The respectful submission is, my lord, and this, my lord, we, during discussion with Mr. Dwivedi, my lord, we came to know. Lord, the distinction is, this is the only state where it was not at par with the rest of the country. And now it is becoming the part. That is, my lord, the distinguishing feature which would never arise in case of any other state. Now, my lord, this UT, my lord, of Jammu and Kashmir came up for consideration of this honorable court. My lord, at page 162, the judgment of...
I closed the compilation volume, so I'll have to research find out where.
Volume 3.
I'm sorry?
Volume 3. Volume 3.
This which you are reading.
Yeah.
My written submissions. But what I've done is, so that your lordships may not have to shuffle through the judgment volumes, I have quoted the paragraphs I am relying upon, verbatim.
This para 85 onwards.
Yes, madam. No, madam. Para 85 onwards. Yes, madam. I'm skipping the paragraphs. I'm just reading the judgments.
I'm just locating. I have the page. That's all.
Yes, yes.
Right.
I'll read the judgments, madam.
First,
Your lordships, I have noted the judgment of this court, my lord, in case of Jammu Kashmir. The present reorganization. Article 3 provides that Parliament may by law form new states and alter the area's boundaries.
Para 89.
I'm sorry.
Para 89.
Para 89. I'm sorry. May I read?
Yes.
Article 3 provides that Parliament may by law form new states and alter the area's boundaries or names of the existing states. The explanation 1 provides that in clauses A to E and Article 3, a state includes union territory. Thus, explanation 1 makes it amply clear that the power of Parliament under clause A of Article 3 to make a law to form a new state or to alter a boundary of a state includes a power to make a law to form a new union territory. Explanation 2 clarifies that power conferred by clause A on Parliament to enact the law to frame a new state includes a power to form union territory by uniting parts of any state or union territory to any other state or union territory. Not kindly come to para 26, at page 163. On conjoint reading of Article 3, 4 and 239A, we find that Parliament, by making a law, can convert an existing state into one or more union territories. B. Parliament is empowered by law to create a body of legislature for the union territories of Puducherry and Jammu and Kashmir. Accordingly, subsection 2 of section 14 of Jammu and Kashmir Reorganization Act provides that there shall be a legislative assembly for union territory of Jammu and Kashmir. And C. Even if law made by Parliament creating a body of legislature for union territories of Puducherry and J&K has the effect of amending certain parts of the Constitution, it shall not be deemed to be an amendment of the Constitution for the purpose. But if your lordship sees holistically Article 3 and Article 4, and I am saying this academically, I am not pitching it, my lord, for this particular case. But there is nothing, if we read as a common scheme of, my lord, reorganization, that one state, for a good reason, the threshold of your lordship satisfaction would be higher. can be converted into UT. Because 4 says some incidental provisions can even include something which may otherwise amount to amendment, but would not be treated as an amendment under 368. Then, my lord, Pradeep Chaudhary, my lord, I'm skipping. Your lordship.
1 and 2 were made applicable to Jammu and Kashmir. No?
Yes, but what happened was, during the first arguments of the petitioners, they pointed out the Article 3 as applicable to the state of Jammu and Kashmir, which provided that nothing can be done without consent of Jammu and Kashmir Assembly. Without pointing out to your lordships that before this reorganization act was placed before the house, the entire constitution was made applicable. Therefore, that proviso goes. Now, what Article 3 your lordships have applied, my lord, when this reorganization took place. Lord, I hope I am able to make myself clear. What was shown was the earlier constitution as applicable to Jammu and Kashmir, Article 3 as applicable to Jammu and Kashmir, which provided for a mandatory consent. But first, the President issued 272, CO 272, applied the whole constitution, meaning thereby what we are reading now as Article 3 was Article 3 when reorganization took place.
What's the date of reorganization? What's the date of reorganization?
It was passed on 6th of August. In both houses. Lord, this is, Berubari is considered. Lord, Berubari, your lordships are aware, my lord, has no application. A part of India was being ceded to some other country. That was the concept. That was the fact situation arising in Berubari. There was a mistake in Berubari, which 5-judge bench in Ram Kishore notes and corrects. And thereafter, there is an amendment to the constitution, knowing that now there was a mistake in Berubari. I'll show, my lord. Please come to para 91 at page 164. Only, my lord, the relevant parts I have quoted and I'll read. This is a 5-judge bench, my lord, speaking to my Lord Justice Gajendra Gadkar. Before proceeding to deal with the points which have been raised before us by Mr. Mukherjee on behalf of the appellants, it is necessary to advert to the opinion expressed by this court in re the Berubari Union and Exchange and Enclaves, so-and-so. The Berubari Union at para so-and-so, with a view to correct an error which has crept into the opinion through inadvertence. On that occasion, it was urged on behalf of the Union of India that if any legislative action is held to be necessary for implementation of Indo-Pakistan Agreement, a law of Parliament relating to Article 3 of the Constitution would be sufficient for the purpose and that it would not be necessary to take any action under Article 368. This argument was rejected. In dealing with this contention, it was observed by this court that the power to acquire new territory and the power to cede a part of the national territory were outside the scope of Article 3C of the Constitution of India. This court then took the view that both the powers were essential attributes of sovereignty and vested in India as an independent sovereign republic. While discussing the significance of the several clauses of Article 3 in that behalf, it seems to have been assumed that union territories were outside the purview of the said provisions. In other words, the opinion proceeded on the basis that the word state used in all the said clauses of Article 3 did not include the union territories specified in the first schedule. Apparently, this assumption was based on the distinction made between the two categories of territories by Article 1(3). In doing so, however, the relevant provisions of the General Clauses Act were inadvertently not taken into account. Under Section 358B of the said Act, state, as respects any period after the commencement of the Constitution, 7th Amendment Act, shall mean a state as specified in the first schedule to the Constitution and shall include a union territory. This provision of General Clauses Act has to be taken into account in interpreting the word state in the respect of clauses of Article 3, because Article 367(1) specifically provides that unless the context otherwise requires, the General Clauses Act shall, subject to any adaptations and modifications that may be made therein under 372, apply for the interpretation of this Constitution as it applies for interpretation of an act of legislature. Therefore, the assumption made in the opinion that Article 3 in its several clauses does not include union territory is misconceived, and to that extent, the incidental reason given in support of the main conclusion is not justified. My Lord, after this judgment, my Lord, 18th Constitution Amendment is made. Judgment is, my Lord, 27th August 66. I'm sorry, the judgment is 1965.
What is the date in 1965?
Lord, I'll just give the Lordship may give me a minute. The amendment is, my Lord, 27th August 68.
27th August?
66. 27th August 66.
And just give us Ram Kishore's.
By which, my Lord, these explanations came to be added.
Right.
That state includes UT. That was, my Lord, the result of this Ram Kishore Sen judgment. My Lord, if your Lordship would like to see where it is PDF volume, I'm sorry, volume 6, case compilation volume 6.
For what? Ram Kishore judgment.
Ram Kishore judgment. Your Lordship wanted Ram Kishore judgment?
Yes, sir. Just the date. Just give us the date, that's all.
My Lord, 11th August 1965.
All right.
This is prior to.
Now, your Lordship, my Lord, kindly directly go to Lord, your Lordships have seen page 167, the view of Justice Khanna, my Lord, Justice Khanna, Delhi High Court. And thereafter, my Lord, I'll read Mangal Singh little later because it's not, my Lord, quoted here. Please come to 169, page 169. State of West Bengal. And read only the highlighted part. Now, my Lord, I am confining to highlighted part. My Lord, your Lordships, only, my Lord, note, my Lord, there is some typo. 1964 1 SCR, page number is not mentioned, my Lord, 371. You can correct. Page 169, citation. 371. May I answer? Look, this is a judgment by 6 honorable judges bench. The legal sovereignty of Indian nation. Your Lordship, guess, my Lord, Justice call, my Lord, para 101. 101. The judgment is, my Lord, State of West Bengal versus Union of India. Yes. Legal sovereignty of the Indian nation is vested in the people of India, who, as stated by the preamble, have solemnly resolved to constitute India into a sovereign democratic republic for the object specified therein. The political sovereignty is distributed between, as well as we will presently demonstrate, the Union of India and the states with greater weightage in favor of union. Kindly come down, my Lord, to para 35 of the judgment, only the underlying portion. There are no independent constitutions of the states apart from the National Constitution of Union of India. Chapter 2, Part 6, from Article 152 to 237 deals with states, the power of legislature of the states, the power of executive and judiciary. What appears to militate against the theory regarding the sovereignty of the state is the wide power with which the parliament is invested to alter the boundaries of states and even to extinguish the existence of a state. There is no constitutional guarantee against alteration of boundaries of the state. By Article 2 of the Constitution, the Parliament may admit into the Union or establish new states on such terms and conditions as it thinks fit. And by Article 3, the Parliament is by law authorized to form a new state by redistribution of territory of a state or by uniting two or more states or parts of states or by uniting any territory to a part of the state, increase the area of any state, diminish, etc. Then 4 lines from thereafter, Parliament. The word starts with Parliament. Parliament is therefore by law invested with authority to alter the boundaries of any state and to diminish its area so as even to destroy a state with all its power and authority. That being the extent of the power of Parliament, it would be difficult to hold that the Parliament which is competent to destroy a state is, on account of some assumption as to absolute sovereignty of the state, incompetent effectively to acquire by legislation designed for the purpose of property owned by the state for government purposes. Then next is, again, Babulal Parate is 5-judge bench. Babulal Parate, this is different, not that 19(1)A judgment. That is also Babulal Parate, my lords, recollect, my lord, freedom of speech and expression. Lord, here, views, my lord, the assembly's views were taken from Bombay Assembly for ABCDE areas. And when the Reorganization Act, Act was passed, my lord, it was some additional areas were also, my lord, therefore that was under challenge. We proceed now to consider these contentions. It is necessary to state at the outset that our task is to determine on a proper construction the true scope and effect of Article 3 of the Constitution with particular reference to second condition laid down by the proviso thereto. We bring it to our task such consideration as are germane to the interpretation of an organic instrument like the Constitution, but it will be improper to import into the question of construction doctrine of democratic theory and practice obtaining in other countries unrelated to the tenor, scheme and words of the provision which we have to construe. Lord, kindly come to the later part, my lord. Article 1 of our Constitution, Lord, somewhere in the 10th line from bottom of 170. Does your lordships get me?
Yes.
Article 1 of our Constitution says that India is a union of states and the territories thereof are specified in the schedule. There is therefore no difficulty in understanding what it meant by expression state in Article 3. It obviously refers to states in the first schedule, and the legislature of state refers to the legislature which each has under constitution. That being the position, we see no reason for importing into the construction of Article 3 any doctrine, consideration of the sanctity of rights of states, or even for giving an extended meaning to the expression state occurring therein. None of the constituent units of Indian Union was sovereign and independent in the sense the American colonies or Swiss cantons were before they formed their federal unions. The Constituent Assembly of India, deriving its power from the sovereign people, was unfettered by any previous commitment in evolving a constitutional pattern suitable to the genius and requirement of the Indian people as a whole. Unlike some other federal legislatures, Parliament, representing the people of India as a whole, has been vested with the exclusive power of admitting or establishing new states, increasing or diminishing the area of an existing state, all altering its boundaries, the legislature or legislatures of the states concerned having only the right to an expression of views on the proposals. It is significant that for making such territorial adjustment, it is not necessary even to invoke the provisions governing constitutional amendments. Then, my lord, Raja Rampal, only one line, my lord, I'll now coming down to one line, my lord, kindly, my lord, appreciate. It says India is an indestructible union of destructible units. Raja Rampal, my lord, again, 5-judge bench. Law, my lord, I am pointing out. I am not pitching that argument that high, my lord. What we have done is, as a temporary measure, as it is clear from day one, the parliamentary debates, that we have created two units, namely two union territories, and one union territory is with legislature, the power vested with the power of police with the center. Because of the very peculiar nature of the situation arising since decades. Rest everything they have, what state has.
Pointed out two instances where it has happened. First was Punjab. That was a very peculiar problem. Punjabi Suba movement, etc. More or less everybody was agreeable, probably it could not muster through the legislative assembly.
No, there was no assembly.
There
It was during governor's rule.
no, I understand that, but earlier it could not muster through the division of Punjab between Haryana and then parts of Punjab going to Union Territory first, even Himachal Pradesh, then Himachal Pradesh itself becoming a state. And then probably Cochin and Travancore is the other example which was given. The third is this. This is a way, because once you suspend the proviso, then virtually the power of the state governments are taken away. The representation of the state is represented by the will of the people of the larger country.
Correct.
Can lead to.
That is, my lord, touched upon in Bomai, SR Bomai. My lord, please come to page 173. Even this question was, my lord, considered in Bomai judgment. We read Bomai judgment for a different issue, but this was also one of the consideration, one of the factors which fell for consideration of the court. Page 173. Where the court considers what is the scope and ambit of the state's views. That's why I'll, rather than paraphrasing, I'll read. But kindly see SR Bromai, para 108. But para 108, my lord, just is called page 173. I have quoted SR Bomai. But last 4 lines on that para. But I'm trying to rush, my lord, so that I can finish. Your lordship gets on a conjoint reading, my lords. My lord Justice Khanna gets on a my lord Justice Suryakant and yes. On a conjoint reading of these articles, it becomes clear that Parliament has the right to form new states, alter existing states, or the name of any existing state. Thus, the Constitution permits changes in the territorial limits of the states and does not guarantee their territorial integrity. Even names can be changed. Under Article 2, it is left to Parliament to determine the terms and conditions on which it may admit any area into the Union or establish new states. In doing so, it has not to seek the concurrence of the state whose area, boundary, or name is likely to be affected by the people. All that the proviso to Article 3 requires is that such cases the President shall refer the bill to the legislature of the states concerned, likely to be affected, to express their views. Once the views of the states are known, it is left to Parliament to decide on the proposed changes. Please, my lord, note, Parliament can, therefore, without the concurrence of the states or states concerned, change the boundaries of the state or increase or diminish its areas or change its name. These provisions show that in the matter of constitution of states, Parliament is paramount. This scheme substantially differs from the federal setup established in the United States of America. So, my lord, it is in substance, in my respectful submission, said that it's a provision which is strict compliance is not insisted upon, provided there is a broader compliance, namely the entire nation, considering that this affects the nation as a whole. This situation doesn't affect the state only or neighboring states only. This affects the entire nation and therefore including representatives of Jammu and Kashmir. Parliament and Rajya Sabha, Lok Sabha and Rajya Sabha have representatives of Jammu and Kashmir. Lord, these are my judgments on 3 and 4. Would your lordships like to have a bird's eye view of the act?
All right.
Lord, volume 3, documents, page 112. I won't take more than, my lord, 5 minutes to do this. I am, my lord, tempted to show this because nobody has shown, which could not have been my objection, but without showing, several statements were made that we are reduced to nothing, everything is taken up. Therefore, my lord, it is my duty to point out just bird's eye view, my lord. Page 112.
Volume 3.
Volume 3, document volume 3, my lords. Page 112. But please see, definition, assembly constituency is defined 2C. It has all attributes of a state. It is state with UT with legislature, but all attributes of a state. Assembly constituency, your lordship gets 2C. Am I with your lordship?
Yes.
Then election commission 2D. Then 2G, my lord, on the next page, 113. 2G, legislative assembly. J, population ratio and union territory. Please, my lord, see the formation of union territory of Ladakh without legislature. Then, my lord, formation of union territory of Jammu and Kashmir with legislature. Correct, my lords? Then come to, my lord, page 114. No reduction. They say that our representation in parliament is reduced. On and para 10. On and from the appointed date, there shall be allocated 5 seats to successor Union Territory of Jammu and Kashmir and 1 seat to Union Territory of Ladakh in the House of People. Earlier they had 6. Now it is 5 plus 1, 6. Then
Did you get that?
delimitation of I'm sorry.
That's section 10.
Section 10, my lords. My lord, the argument of Mr. C.U. Singh was that we have lost representation in parliament. Then somebody said that our seats are reduced. Lord, Mr. Nafde said the seats are reduced. It was 6 in total. Now it is 5 Jammu and Kashmir and 1 Ladakh. Then, my lord, 12. Every sitting member of the House of People representing a constituency which, on the appointed day by virtue of the provisions of section 10, stands allotted, with or without alteration of boundaries, to the successor Union Territory of Jammu and Kashmir or Union Territory of Ladakh, as the case may be, shall be deemed to have been elected to the House of People by that constituency as so allotted. So they continue as Lord Lok Sabha members. Then 13. All and from the appointed day, the provisions contained in Article 239A, which are applicable to Union Territory of Puducherry, shall also apply to the Union Territory of Jammu and Kashmir. So, my lord, now, my lord, this is amended. My lord, this is amended. What is placed is not amendment. My lord, I'll just place your lordship, my lord, the copies of the amended act. I'm not reading from this act, my lord, I'll give copies to the other side also. Because this has all the acts which are made applicable, which were not applicable, central acts, including beneficial legislation, and suitable amendments in the local acts. Local acts are retained if they are not repugnant to the central acts, with suitable modifications making them constitution compliant. Well, this is amended, section 13, because the argument was that now we can't vote. MLAs of Jammu and Kashmir cannot vote. Lord, at page 10, foot of the page, section 13. My Lord Justice Gawai and Justice Suryakant has that. Page 10 of this book, my Lord. Amendment is in this book, therefore, my Lord, I am. Page 10, right side, left side, top is the pagination. Section 13. on and from the appointed date, the provisions contained in Article 239A or any other article containing reference to elected members of Legislative Assembly of the state, which are applicable to Union Territory of Puducherry, shall also apply to Union Territory of Jammu and Kashmir. So they can vote, my lord, wherever MLA is required to vote. In, for example, the example given by petitioner was presidential election. Then 14, my lords. I have one copies. Section 14. There shall be an administrator appointed under Article 239A of the Constitution for the Union Territory of Jammu and Kashmir and shall be designated as Lieutenant Governor. The total number of seats in the Legislative Assembly would be 107. Then, my lord, every entry except police. Police is, my lord, now for obvious reasons, my lord, I need not even explain why police is, my lord, directly under the control of the center. My lord. And clause 6, my lord, this comes for the first time. 14.6. This was never there. Seats shall be reserved for scheduled caste and scheduled tribes in the Legislative Assembly of the Union Territory of Jammu and Kashmir. This has come for the first time. Then come to, my lord, section 16. Lord, earlier only permanent residents could contest elections under section 16. I'm not inviting your lordship's attention to read it. Now, he should be a citizen of India. He need not be a permanent resident for being qualified to be elected, my lord, like any other state, my lord. My lord, please come to the relevant entry, my lord, the relevant section, my lord, is at page 119, bottom, section 32, extent of legislative power. Lord, subject to my answering your lordships about the election on, my lord, day after, when, my lord, in the morning. But
119 of your compilation or?
no, my lord, the act. That's volume 3, my lord, same act. I'm reading from the act, my lord. Page 119, section 32. Volume 3, document volume 3, my lord. Your lordships have 32. Subject to the provisions of this act, the Legislative Assembly may make laws for the whole or any part of the Union Territory of Jammu and Kashmir with respect to any of the matters enumerated in state list, except the subjects mentioned at entry 1 and 2, namely public order and police, respectively, or the concurrent list in the 7th schedule to the Constitution, insofar as any such matter is applicable in relation to Union Territories. Then, my lord, 35, inconsistency between the laws, my lord, there is a provision. Special provision as to finance.
Follows the Delhi model. Delhi model.
Has land.
Delhi, of course, 1 and land. 1, 2, and 18 is carved out. Land is given to the state legislature.
No, land is not given.
Not given. Where is land accepted? Which provisions is land taken away?
Not here, not here. Here only police and public order.
Right.
But in Delhi.
I thought you were saying land is also taken away.
No. In Delhi, it is public order, police.
And 1, 2, and 18.
1, 2, and 18. Your lordship, sir, Lord, we have troubled your lordship, sir, for a long period, my lord, on that. I wanted to avoid that part, my lord, but it is.
It's argued so many times that even 1, 2, and 18 stuck like a mantra in the brain, you know. So.
But here, my lord, 18 is not there, my lord. It is only public
One,
order and
two.
police.
Yeah, public order and police.
And for, my lord, reasons obvious, the very object and purpose of reorganization is this. Well, thereafter, there are financial bills provisions.
One more change. Parliament has competence on all the three lists.
That is because of 239AA. My lord, not here, it's not there.
So unlike a state legislature, in the case of union territories like Delhi, for instance, Parliament can enact a legislation on any item.
No, that is because of 239AA.
Double A. But I'm
Here-
saying the same principle is followed here.
I don't think, my lord.
It is
Subsection
Here,
2.
239,
subsection 2. Nothing in subsection 1 shall derogate from the powers conferred on Parliament by the Constitution to make
yes,
laws
yes.
with respect to any matter for the union
so, my
territory.
lord, that 239AA provision is incorporated in the statute. Your lordships are right. My lord, there is a consolidated fund, my lord, which Mr. C.U. Singh says it's taken away. Annual financial statements, audit by the CAG. My lord, this is an official language, my lord. For the first time, there is an official language, my lord. I wish this was pointed out to your lordships, my lord, while saying that we have been deprived of everything. It's just a UT. It is a state, my lord, for all purposes except these two entries. I'm not going into the minute details, my lord, but it's a Lord, Mr. C.U. Singh argued that the assets are also merged with Union of India.
Actually, nothing turns on it in this case. It's almost like trivia right now. But clause 2 says nothing in subsection 1, 32, shall derogate from the powers conferred on Parliament by the Constitution to make laws with respect to any matter for the Union Territory of Jammu and Kashmir or any part thereof. So this provision does not empower Parliament to make a law on the state list.
Like 239AA.
The provision comes in 246(4). 246(4) says
Yeah.
Parliament has power to make laws with respect to any matter for any part of the territory of India not included in a state, notwithstanding that such matter is a matter enumerated in the state law.
No, that is at par with everyone.
That's why, no, just as a matter of constitutional position, Parliament can enact a law on all the three lists for Jammu and Kashmir.
Even in absence of subsection 2, it could have.
That's right. That's Article 246(4).
Constitution operates.
That's a constitutional position.
So I am not reading, my lord. Mr. C.U. Singh, my lord, said that even the assets will go to, has gone to the central government. So there is a specific provision, apportionment of assets. Jammu and Kashmir assets remain with Jammu and Kashmir, and Ladakh assets went to Ladakh. That's how, my lord, whenever reorganization takes place, the things happen. Now, my lord, I may come to Article 356. But kindly come to my written submissions. And this is, my lord, the last part of my submissions, my lord. I have already crossed my time, my lord, but 142. Yes, my lord, I am placing it for your lordship's consideration. Lord, the governor's rule is in challenge, as I have pointed out, after 14 months.
Which PDF?
142, my lord. My written submissions, 142. Volume 3, 142. Your lordships have a chart, my lords.
Yes.
What I have done is, I have mentioned the number of the petition with the name. prayer prayed for, and the grounds for challenging this proclamation. These are the only petitions and these are the only grounds in those petitions. The Lordships are aware, my Lord, how a constitutional act of imposition of governor's rule or president's rule is to be challenged, and what should be the averments. What was the material, sufficiency, this, that, another? Nothing, because it was done after 14 months, only as a corollary of challenging 5th and 6th of August action. I'm not reading, my Lord, the pleadings, but there are no pleadings. My Lord, that's all I am saying. Lord, now, Lord, I am not reading, but there are no pleadings that it is arbitrary, it is illegal, and therefore declare it to be a void. That's all. Nothing, no pleadings. Only technically a prayer is there. That's what, my Lord, they can argue. Therefore, they have made a prayer after 14 months without pleadings. Now, please come to, my Lord, 146 of this very note, my Lords. On the question, so this is again S.R. Bomai. I am on page 147. Lord, I am going fast. I've seen your Lordship's eyes looking at the clock, my Lord. I am also on the clock.
No, that's not. Please don't have any such feeling.
On the lighter side,
crucial.
Lord, it's
That eye goes to the clock just as a matter of training, that's all.
on the lighter side, what I am saying, so that
Not directed to the attorney also. More than 22 years of training on this.
Exactly, more than 22 years of training. Mr. Solicitor, when we were judges of the Bombay High Court, we had a colleague who had come from Gujarat on transfer, a God's good person. So he had this specialization. We would meet outside the Chief Justice's chamber every morning. Just a little bit of camaraderie, and then we go to So every day, our colleague who had come from Gujarat would tell us how many more days there are to go back to the vacation.
yes.
So,
But it is
there
said
are
that
66 days left for the vacation.
but it is like many other parts, Lord, it is said that a Gujarati can come out of Gujarat. Gujarat never comes out of him. we always. Lord, 146, last, my Lord,
Yes,
part,
creative.
only underline portion. 147. Bomai, my Lord, S.R. Bomai. So this, my Lord, kindly read, my Lord, the canvas of the court's jurisdiction. In fact, once the issuance of proclamation is held valid, the scrutiny of the kind and degree of power used under the proclamation falls in a narrower compass. There is every risk and fear of the court undertaking upon itself the task of evaluating with fine scales and through its own lenses the comparative merits of one rather than the other measure. The court will thus travel unwittingly into the political arena and subject itself more readily to the charges of encroaching upon the policy making. The political ticket objections sticks more easily in such circumstances, although therefore on the language of Article 356(1), it is legal to hold that the President may exercise only some of the powers given to him. In practice, it may not always be easy to demonstrate the excessive use of power. My Lord, why I am reading this, Mr. Sibal read the first part of it. My Lord, his attention, my Lord, missed this last part. My Lord, therefore, I am, for completion, this is the law, my Lord. Lord, kindly come to the next judgment, my lord, at page 148, State of Rajasthan versus Union of India. Lord, 7 honorable judges, my lord. Lord, the bold part, my lord. There is a part which is made bold. The learned counsel, your lordship gets, my lord. My lord Justice Gawai gets, my lord, the bold part. The learned counsel, appearing on behalf of the petitioners in the writ petitions, contended that it is clear from the provision enacted in Article 356, Clause 3, that the exercise of power by the President under Clause 1 is subject to the control of both houses of Parliament. The proclamation issued by the President under Article 356, Clause 1 would cease to be in force at the expiration of 2 months unless it is approved by both houses of Parliament. Prior to, my lord, it was 2 months. Houses of Parliament, and therefore no irretrievable action such as dissolution of the Legislative Assembly of the state can be taken by the President before the approval of both the Houses of Parliament is given to the proclamation. He also restricts that irretrievable action can be taken, but not before it is approved by both the houses. Otherwise, the parliamentary control would be defeated and it would be possible for central government to present a fait accompli to the 2 houses of parliament, and neither house would be able to remedy the mischief done even if it disapproved the proclamation. Moreover, either house of parliament may disapprove the proclamation even before the expiry of 2 months, and where that happens, the President would be bound to revoke the proclamation immediately, because the proclamation cannot continue in defiance of the will of either house of parliament without destroying the collective responsibility of Council of Ministers to the House. It was also, this is the contention, it was also urged that during the period of 2 months, no power can be exercised in virtue of the proclamation, which would bring about a final and irrevocable consequence if the President has reason to believe that either House of Parliament may not approve it, or also the control of the House of Parliament would be completely set at naught, and executive would be able to take irreversible action like dissolution of assembly by passing both houses of parliament and ignoring their wishes.
In Rajasthan, state of Rajasthan, somewhat affected by the subsequent decision in Bomai?
Yes,
because Rajasthan was 77. That was when Mr. Charan Singh wrote the letter to
the... No, it comes subsequent.
And I thought that Rajasthan is substantially diluted by Bomai.
It is, my lord. That's what, that part I am going to read.
Yes.
But therefore, I have put it, my lord, chronologically so that your lordship gets everything at one, in one document without shuffling.
This is not the majority decision. This is Justice Bhagwati's decision, not the majority decision.
In Rajasthan.
Yes. Majority, I can show, this is a better worded from my point of view. Majority says the same thing. I'll show, my lord, those paragraphs tomorrow. So let's not, my lord, give off the cuff, my lord, answer. 165, I'm sorry, my lord. Let me not give off the, I'll put it, my lord, that way. It would be clear from this discussion that when a proclamation is validly issued by the President, same judgment, my lord, para 146.
All right.
I'll, my lord, give, I'm not reading, but I'll give the majority also, saying the same thing. But wording wise, I found this to be matching my submissions more. It would be clear from this discussion that when a proclamation is validly issued by the President under Article 356, Clause 1, it has immediate force and effect the moment it is issued, and where by proclamation the President has assumed to himself the powers of the governor under subclause A, he is entitled to exercise those powers as fully and effectively as the governor during the period of 2 months when the proclamation is in operation. There is no limitation imposed by any article of the Constitution that these powers of the governor can be exercised by the President only when they have no irreversible consequences, and where they have such consequence, they cannot be exercised until the proclamation is approved by both houses of Parliament. Here in this case, I must add, they are approved also when the decision was taken by both the houses on all occasions. Whilst the proclamation is in force during the period of 2 months, the President can exercise all the powers of the governor assumed by him, and the court cannot read any limitation which would have the effect of cutting down the width and amplitude of such powers by confining their exercise only to those cases where no irretrievable consequences would ensue, which would be beyond repair. When any power of the governor is assumed by the President under the proclamation, the President can, during the 2 months when the proclamation is in force, do whatever the governor could in exercise of such power, and it would be immaterial whether the consequence of the exercise of such power is final and irrevocable or not. To hold otherwise would be to refuse to give full effect to the proclamation, which, as pointed out above, continues to operate with full force and vigor during the period of 2 months. It would be rewriting Article 356 and making approval of both houses of Parliament a condition precedent to the coming into force of the proclamation so far as the particular power is concerned. Now kindly see, my lord, only the bold part. It is true that once the Legislative Assembly of the state is dissolved by the President in exercise of the power assumed by him under the proclamation, it would be impossible to restore the status quo ante if the proclamation is not approved by both houses of Parliament. But that is the inevitable consequence flowing from the exercise of the power which the President undoubtedly possesses during the time that the proclamation is in force. Then again, my lord, only the bold part. It is therefore not possible to exceed. But the rest I am not skipping because it's against me. I am skipping because I'm in a hurry. That kindly take him. If your lordship would like me to read, I can read everything. It is therefore not possible to accede to the argument of the petitioner in the writ petitions that during the period of 2 months before approval of the proclamation by the two houses of Parliament, no irreversible action such as dissolution of the Assembly of the state can be taken. The power to dissolve the Legislative Assembly of the state cannot also be denied to the President on the ground that the proclamation may not be approved by one or other house. In the first place, the existence of a constitutional power or the validity of its exercise cannot be determined by reference to a possible contingency. The court cannot enter into the realm of conjecture and surmises and speculate as to what would be the position at the expiration of 2 months, whether the proclamation will be approved by both houses of Parliament or not. Secondly, it is entirely immaterial whether or not the proclamation is approved by both houses of Parliament, because even if it is not so approved, it would continue to be in force and effect for a full period of 2 months. Lord, this is diluted in Bomai, SR Bomai. My lord, please come to page 150, next page, my lord. Justice Sawant and Justice Kuldeep Singh's judgment. (153), my lord, are the summary of conclusions. On this point, it is conclusion number 4, Roman 4. Since the provisions contained in clause 3 of article, am I with your lordship, my lord? On my lord, justice call, my lord, page 150. Since the provisions contained in clause 3 of article 356 are intended to be a check on power of the President under clause 1 thereof, it will not be permissible for the President to exercise powers under subclause A, B, and C of the letter clause to take irreversible actions till, please mark this, my lord. This is the only dilution and this is the only limitation. Till at least both the houses of Parliament have approved of the proclamation. And this is definitely the majority. Yes, please. So, Lord, here, when the actions which are impugned were taken, they passed the muster thrice. The proclamation passed the muster thrice. Then, my lord, then Justice Pandian, I find myself in agreement with the opinion of Justice Sawant on his conclusion 1, 2, and 4 to 8, with which Justice B.P. Jeevan Reddy concurs in his judgment. So this becomes, my lord, a majority view. And last, my lord, Justice Jeevan Reddy and Justice Agarwal, in light of the reasons given and conclusions recorded herein above, we find ourselves in agreement with conclusions 1, 2, and 4 to 7 in the judgment of our learned brother Sawant, Justice Sawant, delivered on behalf of himself and Justice Kuldeep Singh. We are also in broad agreement with conclusion number 8. My lord, then Badrinath is the last judgment, my lord, I'll read. Only the first part, para 25. When an elected, my lord, your lordships have that?
Yes.
My lord Justice Gavai, yes. Page 150. When an elected government is not in office, the orders of the governor under Article 356(1)(a) as an agent of the President of India are equivalent to the orders that might have been passed by an elected government in office, and the governor's orders had to be given effect fully and could not be ignored either by the executive or by UPSC, etc. etc. Then, my lord, kindly come to, my lord, one paragraph of in SR Bomai at page 152. Justice Jeevan Reddy's my lord, exposition on this at page 153. I'm not reading the rest, my lord. Your lordships may, my lord, it gives, my lord, what happens when 356 is implemented. Then at 153, fourth line from the top. My lord Justice Surikant and Justice Gavai has that page. I am on page 153, fourth line from the top. Coming to subclause B, your lordship gets that number?
Yes.
Coming to subclause B, when it speaks of the powers of legislature of the state being made exercisable by parliament or under its authority, it cannot and does not mean or imply dissolution of the legislature of the state. It is significant to note that the subclause refers to legislature of the state and not legislative assembly. In a given state, the legislature may consist of legislative assembly as well as legislative council. In such a case, there can be no question of dissolving the legislative council since it is continuing body. Only the legislative assembly can be dissolved. In other words, there can be no question of dissolution of legislature of the state, the expression employed in clause B. The question may then arise, why was subclause B put in and what does it imply? Because entire legislation is not being dissolved, only assembly is being dissolved. And the court answers. The answer must be that when the government of the state is dismissed or removed from house, the legislative assembly cannot function normally. It is difficult to visualize a legislative assembly or for that matter legislature functioning without a council of ministers, i.e. government. Thus, where the government of a state is dismissed or removed from office, or here resignation, the legislature of the state becomes ipso facto unworkable. It is for this reason that subclause B provides that powers of the legislature of the state shall be exercisable by or under the authority of parliament. The best exposition, my lord, of sub-article B. So, my lord, these are my respectful submissions, my lord. Lord, I am immensely grateful, very patient hearing, my lord, and it's always a learning experience, my lord, before your lord.
Thank you, Mr. Solicitor. Thank you.
Lord, I wanted to read, my lord, the concluding speech of Dr. Ambedkar, my lord, at the conclusion of the assembly, Constituent Assembly. But if time permits, at the end, my lord, I'll read for 5-7 minutes. It's a beautiful speech, my lord, at the end of the parliament. And not right now, my lord, coming in the way of me.
And habits very hard since well, I was trying to read late at night through my iPad, still scribbling on the paper and then making some notes. So it's more than 61 years ago, we had If you lordships recollect, I had given my 2 sets of written submission. Where is that at volume? Detailed written submissions, which is at volume 4. I don't propose to read at length but some essential aspects which I thought can supply by way of a addition to the arguments made before your lordships.
Which volume are you
Before I
referring
do
to?
that, this is volume 4. PDF, it's a page, it's a separate written submission on behalf of the Attorney General for India.
That's volume 4.
That's right. And then I handed over a 2-page note on the last occasion with a summary of my submissions.
Your opening arguments.
Yes, yes. Which company? When 61 years ago, we had Puran Lal Lakhanpal wanting to
Whether he has any health problem.
Oh my God.
Not a very good compliment for me, man.
kept others alive.
Brother Gavi got worried, because he noticed that the same position persisted for 30 minutes.
Fortunately, he was the only one. Fortunately for me, he was the only one.
Fortunately, he is.
Very good.
Yeah.
Please. In continuation of my summary, your lordships have been taken through the whole historical narrations. And in matters like this, it's very difficult to capture their entire history. Through a list of dates narration, we want to communicate to the court what exactly happened for a period of 5 momentous years before 1950. And they convey only a very telescope point of view. And a large amount of literature which is available to all of us to say how this momentous process took shape. Through a variety of efforts and engagements and ideas and conglomeration of thoughts. But by and large, the history has been brought before your lordships. But for the narration of history, the understanding of not only Article 370, but with the constitutional integration process would have been incomplete. And that's where the detailed list of dates narration with the learned solicitor occupies an important space. Now, they said 61 years ago, Puran Lal Lakhanpal wanted to contest an election. Now, his dream has come true. He can contest an election in Jammu Kashmir. He had to wait for 61 years for all of us. All of us are Puran Lal and Lakhanpal, in a way. So this is a grand
Article 370. And second, that recommendation has to be before the president decides to abrogate it. Therefore, to say that, this recommendation is just an opinion, it's not binding on the president.
My submission is not to slight that recommendation role, but I say it's still only a recommendation. Let me try to explain. The necessity of having a recommendation does not add any further content to the role of recommendation. There is a procedure which is required because during the constitution integration process.
So your
many
contention is that
parties
you
were-
have to have a recommendation.
Yeah.
And it's not binding. It may be a positive or negative recommendation. The president can override whatever is said by the Constituent Assembly.
No, the reason why, therefore, what I would call a minimal role of recommendation given to the Constituent Assembly is in the context of one, the scheme of Article 370, and that being part of the larger integration process, can a body like the Constituent Assembly of J&K can have a final say on Article 370? It is not a constituent body of a Parliament of India. It doesn't have all that attributes and powers. So the recommendatory role has been assigned in the context, keeping in mind that once the constitutional integration process is completed, in the understanding of all the parties involved, there has to be a terminus. And to bring the terminus to a completion, then the role of recommendation is assigned. Otherwise, the Constituent Assembly could have been probably given the powers of consultation, concurrence. Why is state government coming into Article 370 at all? So it's only at the end of the day when you have done all that job. It's a stock-taking exercise. And it will probably envisage that you will do it before the constitutional integration process gets over.
What is the sequitur? Are you therefore contending that therefore, since this is purely recommendatory, therefore the absence of a recommendation also doesn't make a difference? Is that the submission or what is the submission?
I'll personally try to address the question. That's only when.
Hundred and three two, yes.
There are different. Oh,
Qualifications. Wherever they want that the opinion or recommendation should be acted upon, they say so. It will be referred to the commission will give an opinion, and then it says, and shall act according to such opinion, which is missing in.
act according to.
Just my note, I have mentioned, I didn't read it, but the President of India being bound solely by a body which is outside the Constitution of India, Lord, may perhaps not be the correct interpretation of our Constitution. That if it says yes, he can do it. If he says no, President cannot do it. Because Constitution of Jammu and Kashmir is beyond and outside our Constitution.
Clause D does the same thing. It says that other provisions of the Constitution can be adopted subject to such modification and exceptions. If they relate to the instrument of accession, consultation. Anything else, concurrence.
Of the state government,
Of this
not Constituent Assembly.
Not to the assembly.
No, but then if the Constituent Assembly was not in existence, then it has to be placed before the Constituent Assembly for its decision. That means even in the case of the operation of clause D, read with subsection with clause 2, the Constituent Assembly is given the overriding power, even in relation to the President.
Till it survives, till it.
There's slight difference. See, you can't say when Article 370 itself refers to Constituent Assembly, you can't say that this Constituent Assembly is outside the Constitution. It's within the constitutional framework because it refers to it. Yes, your argument that once the Constituent Assembly is no longer there, what will be the position with regard to Clause 3 to 370 is something which we'll have to examine. With reference to the procedure you have, with reference to, because the judgments itself, many of the constitutional bench judgments itself says we are not examining that issue. We'll have to examine.
Only worry is, only with permission of the learned AG, the worry is, suppose this exercise would have been undertaken in 2007, in 57, when Constituent Assembly was in existence. Suppose it would have recommended that don't abolish or don't abrogate or apply with modification that none of the provisions of the Constitution of India would be applicable or never apply fundamental rights with that modification. I'm putting a question to myself, the President of India will be denuded of its powers? Was it intended that by not recommending not to abrogate, it would become permanent?
We have taken that argument.
In other words,
That proviso will no longer be applicable after the Constituent Assembly is not there, but that will not deprive the President of his power under Clause 3.
in other words, if the object and the role of Article 370 is essentially and fundamentally a constitutional integration process, anything which emanates from the Assembly, to the contrary, as a way of negation of the integration process, would be forbidden under the scheme of Article 370. You can have a negation there.
Mr. Tony, you extended that argument,
Yeah.
therefore the questions arose. You extended the argument to say recommendation only means advice and even no advice. Suppose the Constituent Assembly was, that's assuming that the Constituent Assembly was,
Therefore,
There-
I quite see. Therefore, what I'm
that
trying-
part, the extension part is the one which is.
Therefore, we have to probably understand the context in which why this provision was at all enacted. The Constitution integration process repeated was the only mantra under Article 370. And everything around it revolves around it. 371 A, B, the Parliament is enabled to legislate, extension of provisions of Constitution, they all revolve around this central theme.
See, the only thing is in relation to Jammu and Kashmir, one thing is very clear from reading Article 370. It expressly recognizes the instrument of accession. Categorical recognition of the instrument of accession in Article 370 itself. Second, a categorical recognition in Article 370 of the process of the formation of the Constitution of the state of Jammu and Kashmir. Third, a categorical recognition of the status of the Constituent Assembly of Jammu and Kashmir. So therefore, it's not that these were instances which were taking place as a part of the realpolitik in that state. The IOA, the Constituent Assembly, the process of constitution formation in Jammu and Kashmir. They are expressly recognized in Article 370.
You're right. My head is
So
small
they have been
caveat.
conferred with a certain constitutional recognition, if not a constitutional status, a constitutional recognition in Article 370.
I just want to enter a small caveat because the historical narrative about what happened in the rest of the country towards constitutional integration. As I said, essentially the process was one and the same. Constituent assemblies.
You are right,
formation
Mr.
of
Attorney
states.
General. You are right in Mr. Attorney General to the point that this was in aid of constitutional integration.
Yes,
And as we see that integration was taking place by and by
yes.
from 1957 right through to 2019. So subjects which were completely excluded to the parliament were brought in within the purview of parliament. That was also that was a clear understanding of the constitutional movement towards greater integration of Jammu and Kashmir into the Republic of India and the Dominion of India originally, then the Republic of India. So there was undoubtedly a gradual and imperceptible integration apart from the unconditional accession to India, which we saw right at the outset in Article 3. There's no difficulty about that. But the only point really is this, that there are two ways of looking at Article 373. If the proviso can't apply, we keep 367 apart for a moment. If the proviso to Article 373 cannot apply, does that mean that the power under the substantive part of 370 is completely denuded or lost?
No. The answer will be no. I'll try to.
That's the
power is not lost.
And if that power is not lost, is it a unilateral power then which can be exercised by the president? What Parliament really did was this. They didn't have a constituent assembly in the state of Jammu and Kashmir. There was no constituent assembly. They were exercising this power to abrogate. They followed the 367 course, obviously, with an idea that in the absence of a constituent assembly, there's no legislative assembly in the state. You go to Parliament, which in that sense represents the broad diversity of them.
The decision.
You have the Rajya Sabha, which is the Council of States,
Correct.
which represents the overall diversity of the nation. You have the Lok Sabha, which consists of elected representatives of the nation. But in that process, there's one, I wouldn't say casualty, but one dilution. And that dilution is the role which was ascribed by the proviso to Article 370(3). Now, that role can, as you are trying to sort of elaborate, that role is merely recommendatory. Merely because that role is recommendatory does not mean that it can be dispensed with, because the Constitution provides for a recommendation. When a Constitution provides for recommendation, we can't say that, well, even if there's no recommendation, that's fine, you can override it.
My endeavor is...
Can I just add one thing? Sorry. Sorry to interrupt. You see, after you amend 367, you say legislative assembly is equal to constituent assembly. We have to take it to the logical conclusion.
Right.
We've accepted that it exists, but
That's right. That's how it has.
But my lord, only one question, my lord, and your lordships can consider this, my lord, during this holiday. My lord, suppose in 1957, at the time when the Constitution was framed, Constitution of Jammu and Kashmir,
Yes.
and the Constituent Assembly was dissolving itself, last speeches were made, etc. Suppose it would have said that now, in exercise of our powers under 370, sub-article 3, we recommend the President that the constitution which we have framed, which provide for a semi kind of monarchy, and now therefore you delete 370. Lord, would it not go against the very spirit with which 370 was incorporated? That it has to be temporary and you are an integral part, because 370 sub-article 3 says, notwithstanding anything contained in the foregoing provision, meaning thereby 1 and 2, instrument of accession and Article 1 being applicable. So, Constituent Assembly technically was not bound by 1 and 2. It could have said, then, my lord, would the President be completely denuded and act as per the desire of the Constituent Assembly? It cannot be, for the simple reason that the debates in the Constituent Assembly repeatedly say that this is a temporary provision.
So that's why I said you can't.
You don't have to refer to the debates.
So that's why I said there can't be a negation principle read into the proviso. A principle of negation whittling down the entire scheme of Article 370. You can't read it into the proviso.
let us say, bro, that as Sheikh Abdullah at that time wanted, bro, that independence resolution being passed. That's why you put in registered of the assembly.
It's the way that answer is given in the Article 370.
I'm saying, had they proposed, then the president is not bound.
No. That proposal is not, this will be contrary to Article 370.
That's right.
May I have your lordship's permission in support of this submission?
Contrary to Article 1 also.
Reading material can be shared with,
Kashmir is an interior part of it.
that's all right.
Good question.
Some reading material can be shared with your lordships and then.
No, nothing in terms of reading material, Mr. Attorney.
We have enough reading material with us.
Now we will go by churning material, which we have at the bar.
I didn't want
Because
to.
then in rejoinder, we'll get a couple of thousand pages, Mr. Attorney, and we only know what difficulty that poses at the end to us.
Coming through that, I understand.
Give you a more accurate list of days.
These are some,
We put that discipline on you because we realized what could happen.
no, but what happened?
That was.
No.
So the facts which are on record in the work of Sardar Patel.
This is the, please let us not get into that. I don't
When he
think,
says,
Please,
I don't-
Ms. Sybil,
I don't-
you'll have your chance in the
I
second
don't
round.
think this statement is necessary at all. No, the reading material is some excerpt from certain books. Some thoughts come in the course of how do you explain internal sovereignty, how do you explain certain, I thought if they are useful, I can certainly.
One last word, then we'll rise, of course, then we'll think of all that you've argued for the holiday tomorrow. That the wide chasm between absolute autonomy as it existed on the 26th of January 1950, all right, and complete integration as it was brought about on 5th of August 2019, that chasm had been substantially bridged by what was happening in between. So really, in the sense, it was not a complete migration from absolute autonomy to absolute integration.
it had become a shell, my lord, as
Whether you call it a shell or not,
Gujari Lal Nanda said. my lord,
it's
only
obvious
a shell.
that a substantial degree of integration had already taken place in the last, between 1950 and 2009, 69 years.
The final
And therefore,
point.
what was done in 2019, was it really a logical step forward to achieve that integration?
Absolutely.
Integration was whole already. In 1950, only assimilation was there.
Different meaning for us. The power to make the law.
We have interesting issues, yes. We have interesting issues. Mr. Attorney, about how long would you take? About half an hour or so now?
More if possible.
Sorry?
Maybe an hour more.
After that, Mr. Dwivedi will.
Right.